Second case on this morning's docket, case number 106132, State of Kansas v. Rasmus R. Eddy.
May it please the court, Meryl Carver-Ullman, Capital Appellate Defender, on behalf of Mr. Eddy. And Chief Justice, if I could please have 3 minutes for rebuttal.
3 minutes is granted.
Thank you. As to the first issue in this case, as Ms. Trocheck's 609 letter indicated, I think there's been some case law to the contrary. So I think that ship has sailed. I'll say it that way. So I'm going to go on to the second issue in the brief, which is this Gregg issue that Mr. Eddy asked for and was not granted independent psychological examination of the victim in this case. I think I'm not going to list the Gregg factors out here because I think they're in the brief and I think the court's probably familiar with them also. Safe to say in this case, we're not arguing that this 4-year-old child was lying on purpose or trying to do anything really other than get up and say what perhaps adults had inadvertently planted in her mind. And I think if you look at the facts in the case, you can see the concern for that here. She comes home and her mother immediately begins with questions that are very leading. Did Grandpa touch you? Where did he touch you? Questions like that. And then when she didn't answer those questions for her mother called her grandmother, her mother's mother, and those questions were repeated again. And then I think an aunt was brought in to ask even more questions. So, every forensic interviewing technique that I think we're all familiar with probably being violated there.
But your way to attack that normally is to bring in an expert on interview technique. Because you're saying the child wasn't lying. It was just a faulty interview techniques.
And I think that there's some truth to that too. I think that's something additionally we could do. I guess I don't think they're mutually exclusive.
My problem is when you get up and acknowledge that you're not alleging the child was lying, that when I read the argument from defense counsel for why an evaluation was needed, he more or less is saying they want a human lie detector on this and talking about checking on the victim's veracity. And how does that play in to this when we have no indication that there's any lying? So why do we need to check on something we can see it isn't happening?
Well, I guess my answer to that would be, and perhaps I started saying the wrong thing. I think there's no indication that she's lying on purpose. I think she may be.
But we don't use evaluations to assess credibility. We use the evaluate. The Gregg factors talk about is there something psychological, or is there something going on here that would impact veracity, but we don't just have an evaluation. Do you think she's telling the truth? I mean, that's not the purpose. That's more or less a fishing expedition, which we've said can't happen.
And I agree with you about the fishing expedition part. I think where we disagree is that I believe that when you're talking about a young child like that, I mean, I think that there is a psychological component to the planting of false memories. And it's not really just a question of is she lying or is she not. I think it's more complicated than that, honestly. So I guess that would be my answer to that question.
So the Gregg factors that you think dictated the evaluation were which ones?
Basically, we're talking about the first two factors, which have to do with mental instability and lack of veracity. And again, I realize that we're not saying that this child, has schizophrenia or some other recognized mental disease, but we're saying that the planting of these false memories is a psychological issue. And then also, I think the last factor, which is sort of the catch-all factor, honestly, whether there are any other reasons why the victim should be evaluated. And again, in this case where it was a contentious custody situation already, I think the mother didn't want to let the child go with the grandfather for the weekend because she thought the child was going to be kidnapped actually at first, and had to have some assurances that that wouldn't happen. So I don't think this was unfortunately a happy family situation even before we started with this case.
And both the first two factors, your reasoning is the planting of false memory or the faulty interview technique.
That's the argument, yes.
You're not saying the child is inherently incapable of telling the truth.
I think that they got this child up on the stand because I believe, I think Ms. Trocek was the counsel that did it actually. I believe there was some question about whether she could testify in front of Mr. Eddy or not. And she got up, and I think she satisfied everyone that, she basically knew the difference between the truth and a lie, and that sort of examination that we go through, I think sort of inherently being that age makes that line a little fuzzier than it is with maybe an adult, maybe just to begin with. So that's
Any further presentation for us,
that is all
counsel?
I have, Chief Justice.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, Christina Trocek appearing on behalf of the state of Kansas, who is the appellee in this matter. Addressing issue number 2, the trial court properly denied this motion. As stated in State v. Gregg, there has to be a compelling reason for the court to require a psychological or psychiatric examination of an alleged victim in this type of case. Essentially what the defense...
Why isn't it a compelling circumstance that the child's ability to properly tell what happened has been adulterated by leading questions and by planting false memories?
I wouldn't agree that that happened here.
Well, we're not talking about whether that happened.
Right.
And, I mean, that's the whole point of an evaluation is to see whether it happened. I'm just saying, is that a reason?
If the defense could properly present it to the court and present supporting evidence, then I would agree that that may actually be a compelling circumstance to grant it. But the problem in this case, there was argument presented. The defense counsel relied on the testimony of the preliminary examination. And I would disagree with the assessment that defense counsel made of the evidence presented at preliminary examination. The defense counsel said there was nothing to corroborate any of these counts except for the misdemeanor count of promoting obscenity to a child. And essentially, the defendant really got the ball rolling here with his unusual statements to the mother, circumstances of returning this 4-year-old child to the mother, and immediately stating to her that he had lost this child for an hour and a half, had found her on a computer looking at pornography, that the child had refused to wear clothing at night when she went to bed, that the child kept walking in on him while he was using the restroom, and he returned a bottle of lavender baby oil that he had purchased for this visit with his granddaughter. And the last parting comment that the defendant made was that he was a good guy and he would never break the law. I think naturally that is going to arouse some suspicions, and rightfully so, the mother spoke with her daughter about whether she saw pornography. The other important thing to note here is the defense wants to portray this as a situation where this child didn't disclose anything for a month, but that's not accurate. This child immediately disclosed to the sexual assault nurse that her grandfather had licked her vagina and touched her vagina with his finger. She immediately reported it on May 1st, 2009, before she'd had any contact with law enforcement at that point. I think the record's clear that the victim was done talking after she spoke with a sexual assault nurse on May 1st, 2009, and the investigator who tried to conduct the forensic interview with her could tell fairly quickly that her attention, the victim's attention, was not on the interview, so she concluded it and interviewed the child another day. I think most importantly, too, what corroborates the victim's account here are the defendant's statements to the investigator. In the preliminary hearing, those statements were admitted. The trial court had an opportunity to hear those before he ruled on the motion for psychiatric examination. And in this case, the defendant immediately told the investigators who came out to speak with him that the victim had pulled down his pants while she was at his house. They had watched pornography together on the computer at his residence. The defendant, unsolicited, told the investigator that he had allowed her to slide down his face while she was naked, that the victim wanted to sleep naked at his house. When asked about his computers, the defendant said he had them, but he had cleaned them. The defendant told investigators that while this 4-year-old child was on his computer, he wanted to explain to her that sex wasn't bad. The defendant gave a fairly detailed account of how he was allowing this victim to slide over his head while she was naked. The defendant told the investigators he'd purchased baby oil before he had picked up the victim for this visit. And the victim made the statement that he didn't do anything to come on to this victim. The defendant continued in this interview to acknowledge, when asked if he had licked the victim's vagina, the defendant responded that he had kissed the inside of her thigh, where the victim said she had an owie, his words. The defendant said that he put baby oil on her vagina up to 3 times and had allowed the victim to slide down his face. The defendant said there was possibly contact between his mouth and AE's vaginal area. The defendant went further and said that the victim had pulled on his penis 2 times.
Counselor, we have all that information.
Right.
In
And my
briefs,
point is...
And what do we, what
My
are
point
you,
is-
your point is that his statements corroborated the victims? Is that your point?
Absolutely.
Okay.
Absolutely.
Therefore, there's no reason to have an evaluation.
There was no reason to require
That's
this.
the reason you're reciting all this
Absolutely.
for us, for that point.
And that is one of the factors that Greg talks about is, is there a lack of cooperation in the record? And I would submit there is no lack of cooperation in this record. There is no similar allegations, false allegations against other individuals. There is no evidence of any mental instability. There is no...
Is there evidence that the law enforcement officer used leading questions in the second interview?
Well, actually, when the victim disclosed, the most was when they had taken a break to go to the restroom, and she asked the forensic interviewer to go with her, and it was during the course of the visit to the restroom that the victim said that her grandpa had licked her vagina and touched it with his finger. So I would not characterize this as an interview that was fraught with leading questions that could have produced or could have created some suggestibility. The Gregg factors make it, or the Gregg court makes it very clear, as well as State versus Price, that in order to require a victim to submit to this type of intrusive examination, there has to be a compelling reason. And with what the defense attorney presented to the court in the motion to support his psychiatric examination request, there's nothing in the record that would be that type of compelling circumstance to require this 4-year-old girl to undergo a psychiatric examination. And the state would ask this court to find that the trial court properly ruled on that issue and find that the trial court did not abuse its discretion in ruling in that fashion and affirm the convictions of the appellant in this case. If there aren't any other questions from the court, that would conclude my presentation.
Any further
you.
questions?
Thank you very much.
Thank you. Reserve 3 minutes for rebuttal.
If the court has more questions, I'd be happy to answer them. Otherwise, I'll waive rebuttal.
I did have a question on our standard of review. Opposing counsel just informed us there was no abuse of discretion in the court's ruling. Do you agree that's our standard?
I agree, it's the standard of review, yes.
And which part of the standard of review of abuse of discretion are you hanging your hat on? Is this an error of law, or no reasonable person would take this view, or?
This would
what?
be, I don't believe it's an error of law. I believe it would be under the no reasonable person would take this view standard. I think that's what we're stuck with.
All right.
And-
Go ahead.
And you're stuck with two issues. One, alternative means, and second, refusal of the motion for evaluation.
Those were the issues that we raised, yes, Justice Johnson.
And there's no multiplicity argument.
Not that I saw.
Okay, I just wanted to clarify. Thank you.
Any more questions? I see none. Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.